Good evening, everyone. Carl Steinbeck here. Going to talk tonight about the latest filing of Donna Adelson, her counsel that are from the Jackie Fulford law firm. Jackie Fulford signed off on it, as well as her sidekick, apparently an associate there. And I'm just going to get into the brief here. And I've not spent a lot of time in it, but it's something that is not very impressive to look at. I can tell you that. My impressions of it are that it's really, really looks like someone that doesn't do a lot of pellet brief writing is what this looks like to me. People that do appeals, they're like specialists. Jackie Fulford doing appeal work, I don't know why she'd want to do that. I mean, you make money doing it, but having fresh eyes on it is always the better thing on any appeal case, whether it's civil or criminal. So having the same lawyer that took part in the trial and lost at trial is now going to explain to the court what went wrong, and they're not in the best driver's seat to understand what went wrong from a legal standpoint. People that looking at a fresh record of trial are, and people that do that day in day out, you really have to understand all the nuances of appellate practice, and that's why it's something that I really have never done except one time, and it was pretty much a clear cut issue. But having to go through all these requirements of formatting and line spacing and fonts, and it's really a exact type of thing. You do one little thing wrong and they can like reject your brief. You're not supposed to go over a certain amount of pages. You got certain exact deadlines. It's very precise, and they already blew some deadline and mentioned how they needed more time because of sicknesses and illnesses and things of that nature. So it's very precise, and very much, it reminds me sort of like accounting type practice. You have to be exactly correct. You're not allowed to fudge facts and um, just wing it. So, and if you stop to think about it, the the Jackie Fulford, she runs a nursing home. She's like a director of a nursing home. That's her full-time job. So this is even, not only is she not a part-time, not only is she a full-time trial attorney, she's not even a full-time appellate attorney. And I'd say very rarely has she done these in recent history, if she ever did them in the past. I haven't done research on that, but you can just tell this is not written like it's very clear and formatted very well, and it's just sort of rambling through facts and law. So let's go through some of it. I'm not going to present it on the screen just because there's like 90 pages of it. It is a massive document, but part of the page, um, the large number of pages, because they use big font and double line spacing. So there's not a whole lot said per page. So there's a lot of page flipping on it. I guess I can just at least show you. Let's see. No, I can't. But anyway, her apparently an associate is M. Lilja, Lilja, Dandelake, Dandelake. And then we have Jackie Fulford signing also off on this as counsel for appellant Adelson. So they go through reading a statement of the case and statement of the facts, and statement of the of is, let me see how I'd like to show a few things of this, I guess. File. Here we go. Well, no, it's not. It's not letting me show that. But anyway, if you could see, it looks like an AI generated heading. There was a weird spacing of the word of, where it says statement of the facts. The of is like has a like a half of a line spacing between. That looks like this was written by an AI. And so anyway, you can see this as well. If you just Google Donna Adelson appeal brief, you could probably find it real quick and easy. So anyway, I'm just going to go through it really streamlined here. There's not a whole lot of stuff to get bogged down in. Statement of the case. Of course, they're just saying things that they're cherry picking. They're not explaining the full detail of how this the facts came about, how they were presented by the prosecution, or even what the defense theory is. Um, they give the history of how Rasham had to withdraw as Donna's counsel, and that they're not bringing up any conflict of interest at this time. They'd have to do that in a separate post-trial filing, but they're talking about how the court issued an order on October 7th to 24 disqualifying both Alex Morris and Adam Commissar from further representation. That's how Jackie Fulford and Josh Zellman were then retained. Then they talk about the connection between the parties, between who Dan Markel was, how long he was married to Wendy, when they got divorced, when the murder happened in July 18th of 2014. So it's over 12 years ago. Donna knew Dan very well, always talked kind about him before Wendy got married. And even while they were separate, even after the divorce, she was always kind to them. Although she used a poor choice of words during the divorce process, she would, and when he would say ugly things about Wendy, not one single time did she ever suggest that Danny deserved to be harmed. Never said he intended to be killed or suggested harm to him in any way. Then it goes on to talk about Luis Rivera didn't have any direct contact with Donna. She didn't communicate with Luis Rivera. Talking about Sigfredo Garcia, had a child with Catherine McBanois. They acted like husband and wife. Donna never met Sigfredo Garcia or communicated with any way. Catherine McBanois had a relationship with Charlie for some time, on and off again, also between her and Sigfredo Garcia since they were 18 years old. They had shared a child together. Actually, I think they got that wrong. They shared 2 children together. Donna Adelson may have seen Catherine at one time in the dental office when she had her teeth cleaned. Otherwise, she never did not ever speak to him at any time. Charlie is Wendy's brother. He also practiced out of the same dental office. Donna was nearly in daily contact with Charlie, sometimes seeing or speaking to him multiple times a day. Going into more details about how Wendy met Dan the first year of law school, and they're married in February of 06. Wendy is a sister to Charlie and Rob Adelson and the daughter of Don and Harvey. She met Katie and blah, 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 blah. They talk about some of these different interactions. Donna's mother of Charlie, Wendy, and Rob Adelson, married to Harvey Adelson, also former mother-in-law to Dan Markel. And it says here, listen to this. It says she once had a great relationship with her son, Rob. That's Dr. Rob Adelson of New York, a phenomenal ENT doctor, his wife and their children as well. However, once the FBI convinced Rob that Donna, Charlie, and Wendy had killed Dan Markel, Rob and his wife and children became estranged from Donna, Harvey, Charlie, and Wendy. Man, what a spin. What a spin on that is. That did not that wasn't brought out at trial. They became strange because Donna cut him off because they said, "Hey, what's going on? Who do you think what happened to Dan? What do you think happened?" And you know what? They never had anything to do with him after that. There's that same conversation that had to do with the FBI. They said, "No, the FBI, if they talk, you don't talk to them." He goes, "I already did." That's what Rob said. So once they knew that he was asking questions about who done it, and then he says, "Well, I already did talk to the FBI. I told them what I knew." Then they cut him off. The Florida Adelsons cut him off. Talk about a slipshod filing here. That's pretty That's pretty easy to refute because it's not in the record at all. How can you cite stuff that's not even in the record? Was this generated by AI? Just some way that some of the headings are, it's like really bold, highlighted, underscored. It looks more like a thumbnail for a live stream than it does an actual legal filing. So you throw in AI with some weird fonts, weird spacings. Yeah, also I'm looking at like the line spacing. Let's see. Hold on a minute. I think I need to show this. Let me bear with me, please. This is worth showing. I'm just trying to use a different format to show it. So here's what I'm talking about. This just doesn't look like the font looks off. It doesn't look real clean and crisp. The way the letters are so bolded, it just looks way off. Here's the thing I was telling you about the of. This looks like AI. Leslie, if you're listening, does that look like AI to you? Can you send me a message, please? Look at right here. Here's another sign of AI. I think this is an unnatural spacing between the between and the. They're citing all the different places in the record of trial, but okay, let me jump down here. Look at right here. Here's another indicator. See the spacing? What is that? A half spacing or something? And then look at this kind of font, that bold font. It just doesn't look like it's a serious brief before an appellate court. They're getting more into history, hiring the hitman that killed Danny Markell. They do talk about Charlie and the Hitman joke about the TV is cheaper than hiring a hitman. Let's see. So they are saying here that Charlie solicited Catherine McManus to get involved in murder. Am I reading that right? Solicited Catherine McManus to get involved in murder. Okay. Are they going to go with Charlie's story? Apparently not. Yes. I just got a thanks, honey. I just got a text from Leslie. I'm sorry if I said nursing home. I meant funeral home. Yeah, so Leslie concurs. This is definitely AI. Telltale signs this is AI. So I hope they actually detailed references. I mean, if you start citing made up law, made up facts, you can get in trouble with this with the court. They can sanction you, yank your license, fine you, report you to the state bar. Let's see. Look at this. So Rivera knew that murder had to be done because Markel's about to leave town. Police got the information from Secretary Garcia, who got the information from Katie, and Katie learned about it from Wendy. Wow. Okay. So you're going to admit that. That's good. Rivera did not know Wendy, but knew she was the lady they were killing Markel for to help get her kids back. So it sounds like they're throwing Charlie and Wendy under the bus. As they did this the first time, Rivera and Garcia followed down Markel to the daycare where they watched him drop off his children that morning. They followed the gym. Now, this is at the time of the actual time he was murdered. Markel's, they don't even put apostrophe S. You got a typo there. Okay, this is even a factually incorrect statement. They said he drove all the way to Mr. Markel's driveway. No, he followed to the driveway, but they said he pulled right behind him and he jumped out and shot Mr. Markel twice through the window. At the time he shot, Mr. Markel was parked inside his car in his driveway, sitting in the driver's side on his phone. No, he was actually in the garage. So these defense lawyers working this for so long don't even cite the facts correctly that he was murdered in his garage. He was sitting in the car, the engine was running, and he had the windows up. And Rivera drove the vehicle, that's correct. And Garcia's the one that got out of the passenger side, walked around, and walked up to the car. They're pulled up directly behind it. And then he went and shot Professor Markel through the driver's side window, through the glass. The first phone call was made after the murder was by Katie to Garcia to let her know the job was done. Yeah, so why would they want to kill somebody that they didn't even know, have no connection to? They're showing obviously it was to benefit Wendy. Rivera could hear Katie on the other end of the call, and he was listening in because he wanted to know what they were going to get for the money. After Markel was murdered, Rivera and Garcia stopped somewhere to eat. They went home. They stopped at ATM. They can see him on the video. Katie was paid directly for the murder. Then on the day following the murder, Saturday, she called Luis River. Look at, they can't even spell the guy's name right. Luis River? Okay. I guess he used to have a Hispanic last name, but now it's River. Luis River. That's the kind of thing AI can miss, right? They don't have the consistency throughout there. After speaking with, now it's Rivera again. I mean, can you imagine these judges on the Court of Appeal reading this trashy written brief? They're going to not be happy with it. That same day, Katie then brought some of the money she received for the homicide to Sigfredo, and then together they took Luis Rivera his share. Now he's back to being a Rivera. He got $35,000. Luis Rivera believed Katie got like $40,000. It was total about $100,000 hit, one-time payment. And then he talked about stapled money. Who staples money? Charlie Adelson does. So that's a signature earmark there. Okay, then look at this weird statement here. There was no evidence presented by the state that Donna Adelson had anything to do with the murder of Dan Markel. No evidence she traveled there. They're not going to bring a 75-year-old co-financer of the murder up there to do the hit. Obviously, they try to keep some distance. That's why they hired a third party, because she would have an alibi. No evidence she purchased or provided the gun. She wouldn't have to. These guys were criminals, career criminals. Of course, they would have their own source of weapons. She never offered money to McBanwell, Rivera, or Garcia. So again, they're just cherry picking certain facts. No evidence to prove reality, reasonable doubt. So that's the thing. I mean, an appellate work, you got to explain what actually came out at trial and then put your version of it. You just can't cherry pick facts and then leave out all the incriminating stuff. To say there's no evidence, so you lose a lot of credibility here. So so far when I'm looking at this, it's pretty laughable. And then now they're defending Katie Gann, saying the first time she was contacted by Charlie, it was not a solicitation for him to be murdered, it was for him to be harmed. So, okay, so now they're trying to backtrack off what the intent of the contact with Katie McBanwell was. And keep in mind, I've maintained from the beginning, Katie McBanwell was basically only dating Charlie because he was trying to keep her control over her to make sure she was able to help make contacts to do harm. If she would have said, "No, I don't know anybody that could harm somebody," he would have dumped her right then and there. He wanted somebody that was desperate for money and knew the kind of people that could resort to killing for money. And in that sense, he was absolutely correct in suspecting Catherine McBanwell. And then they're talking about discussion with Katie and Charlie about Dan Markel being harmed, but no evidence that he asked to have Dan Markel murdered. Okay, that they're talking about how Katie testified the only thing she had talked about Garcia was that she had a potential person that needed to get harmed or beaten up. Okay, Patricia Bird. They're talking about that jailhouse paid snitch by Donna. Donna was promising her things. That's who Patricia Bird is. Because if there's no plan to be made to harm Dan Markel and people were solicited to carry out the plan to simply harm Dan Markel, then no reasonable jury could conclude. Anyway, this is just bizarre. Okay, they raised 6 issues on appeal. Let's just go through them here. Sufficiency of the evidence. Trial court erred in denying appellant's motion for judgment acquittal because the evidence was legally insufficient to demonstrate that she was a principal to first-degree murder. The state's theory is that appellant was a mastermind behind the murder of Dan Markel. Specifically, that's what you hear on court TV. They always called Donna Adelson the mastermind when I thought that was incorrect. She's one of the main operational planners and the go-between, but not the mastermind. Specifically, the state argued that the appellant was guilty as a principal to the charge of murder because she agreed to the plan to be carried out and she paid for the crime to be carried out. The problem with the state's theory is that the appellant did not learn about the murder of Professor Markel until it actually already occurred. The state did not present any evidence to show that the appellant knew anything about the murder prior to it being committed. In order to prove first-degree murder, the state had to prove the following elements: that Dan Markel was dead, the death was caused by the criminal act of Donna Adelson, and there was a premeditated killing. Caused by, okay. Caused by can be anything like aiding, abetting, procuring, assisting, anything where you're doing an act to show you were part of this. It could be, for example, if you were if somebody wanted to go rob a bank and they said, "Hey, we're going to go shoot the guard at the bank and rob the cashier. My car broke down. Can you give me your car?" And you hand them the keys. That's enough right there to be a co-principal. So they cite some of the different legal standards here. Yeah, do some act to assist the other person actually committing a crime. Yeah, okay, so let's talk about that. They talk about in a Staten case, they drove perpetrators to the scene of the crime, waited across the street while they committed crime, and then drove them away. Well, Donna's not going to be that stupid, and she's too old to drive all the way up there. So, what do we have here, though? Let's look at what indicators there are that she had premeditation and active assistance of this murder before the actual hit was consummated. All right, so we have the cryptic Harvey's birthday gift exchanges, the March of 2014 text, which had months before Harvey's Adelson's 70th birthday party, which was in July of that year. Donna and Charlie began text messaging about a secretive birthday present. In a key text in March, Donna explicitly wrote to Charlie about securing this present, stating, "I know you'll come through. I know you'll come through for me." And then there was a first failed attempt in June where the hitman drove up to Tallahassee to kill Dan Markel. The very next day, Donna texted Charlie to say that she was driving up to Tallahassee to see her grandsons, and Charlie replied, "Okay, have fun. Still working on Dad's birthday present," to which Donna reassuringly again replied, "I know you'll come through." And then during the investigation and later on trials of Charlie and Donna, Wendy Adelson, the daughter, and then Rob Adelson, Dr. Rob Adelson, both testified they had no knowledge of any lavish, secret, or monumental 70th birthday gift being organized for their father that year. The state had argued that the gift Donna was obsessively chasing was a permanent removal of Dan Markel. It was so obvious that was what was going on in the talking code and all that. What do we also have? The panic over the grandma motion and Donna's threat to the access to the children. And think about it, in 2013, Dan Markel filed what the family infamously dubbed the grandma motion, and that enraged Donna, who was heavily disparaging him and his young sons. And Dan Markel had petitioned the court to legally mandate that all of Donna's visits with her grandchildren were strictly supervised by a third party because she was trashing Dan so much right in front of the kids. Think about the wow reaction. The prosecutors introduced emails from a joint account shared by Donna and Harvey. And when the legal notice of the grandma motion arrived, the response from their end was a stark, panicked wow. And then, so basically, that was the catalyst right there. Unsupervised access to her grandkids was the ultimate catalyst to push Donna from anger to a lethal conspiracy. And then here's a really strong one: the micromanaging of the TV repair and alibis and the code. The coded language was pre-planned. It was so obvious. The Adelson family had these code words established to discuss the logistics of the hit over unsecured lines. The central code word, of course, was the TV or the TV repair. And then think about it. Donna was the one that set up this alibi and this code by she's being the one that ordered the TV repair appointment at Wendy's Tallahassee home, even though she was living down in the Miami area. And that was supposed to happen the exact morning of July 18th, the day of the murder. This ensured Wendy had a documented reason to be away from the crime scene and created a structured timeline to establish an alibi. Think about also the ghostwriting and orchestrating psychological warfare that went on by Donna. Prosecutors show that she was actively posing as Wendy, logging into her accounts to edit relocation petitions and drafted aggressive notes for mediation. Also, the good actress email. Remember that email that Donna was furious and saying that Wendy needed to demand number one thing being able to relocate her kids to Miami. Donna told her daughter, the rest of your life, and consequently, my dad's, mine, and yes, even Charlie's, will be affected by how well you can perform or act. You can be a good actress if you want to. I've seen you in action. She even went to the extreme of having this bogus baptism plot where Donna laid out this really manipulative plot to be able to break Dan Markel's spirit by having Wendy suggest the children pose in front of a Catholic church, take photos, and threaten the beliefs of Dan Markel, he was a devout practicing Jew, that she was going to baptize the boys into the Catholic Church. And then Donna actually said, "You cannot tell anyone this is an act. Take control from him. Get to him psychologically." So this is scorched earth warfare, all initiated by Donna. And to say that she had nothing to do with the planning, it's just so ludicrous. Okay, pre-staging and then washing of the financial capital. Remember, ahead of the execution of the hit, there's this liquidity planning. Donna was deeply involved in the family's financial maneuvers to secure the cash needed to pay off the hitman through Katie McBanois. Think about the moldy cash incident. Donna withdrew and handled tens of thousands of dollars in cash. Prior to handling the bundles over, Donna became paranoid about the condition and smells of the bills. She literally put $138,000 in cash through a washing machine to clean and dry the money so it could be cleanly stacked and bundled in stapled envelopes for the hitman. And think about this. This is what I've said about it, is the reason the money was moldy. If it was freshly laundered right before it was handed to Katie a day or two before, it would not be moldy. I think it was washed before a month prior, at least a month prior, when that month and a half prior before that that money was actually handed over through that failed first attempt effort in first weekend of June, when the hitman went up there to try to take out Dan Markel then. So it got moldy in that month and a half. And so that's why I think that also connects Donna even more so to not just the one hit, but both the consummated hit and the one attempted before that. Then think also about the physical surveillance logged into Donna's personal planner. Um, think about this: her 2014 monthly planner, a physical one, not a digital, and they found Donna had these handwritten exact notes of the make, model, car type, license plate number of Dan's car. And then you have the Donna planner used to log Dan's professional itinerary, teaching schedule, and planning travel dates. Prosecutors use this to show she was gathering the exact logistical telemetry needed to tell the hitman when and where Dan would be vulnerable. So those are some of the strong indicators that there was pre-murder planning involved. So for them to say this, that there was zero evidence, the prosecution should just knock this one out of the park. Yeah, so she did a lot of meddling, and if you think about it, this is sort of like prophetic that she was on Wheel of Fortune, and they asked what her occupation was. She said she was a domestic coordinator, and one of the words she had to solve was mischief maker. So you combine mischief maker and domestic coordinator, and this is exactly what she was doing, trying to tightly control what was going on to get these kids back to South Florida where she could see them, not have to drive to that forsaken land known as Tallahassee. I'm not calling it that, but that's how the Adelsons viewed it, just a country bumpkin hick type of place. Okay, then we're going to go on to. I'm just going to run through this, then I'll take questions at the end. Sorry, this is like 90 pages, so I'm trying to. We're already a third of the way there. But like, as you can see, this is such big type font. I can't believe this meets their criteria. I don't think I've ever seen anything like this big a font, line spacing. But that's what AI can do. It's not going to be good at necessarily following those if you don't know how to tell them what the requirements are for the Court of Appeals. Agreeing, they're talking about proof of the conspiracy alone is not enough. Agreeing with someone to commit a crime or developing a criminal scheme with someone by itself does not establish the person assists in the eventual actual commission of the underlying offense. At a minimum, there has to be proof of some overt act, some words uttered in furtherance of the scheme that led to the murder. Yeah, she's kept on encouraging Charlie. Think about it. Wendy was down there the first part of July. There was plenty of time for all the Adelsons to get together to further coordinate the details of this. Think about Wendy also being there, and she was able to ask Dan, was he going to be there the week of the 14th through the 18th of July, knowing the fact that they had scheduled visitation. So there's no need to ask that. So Donna would have been privy to that information. And they talk about the Denise Williams case. There was no testimony that Denise assisted Brian at the lake. It's when the murder happened, or any testimony that Denise was on the phone with Brian while he was at the lake with Mike, goading her, encouraging him to go through it. And there's also a lot of phone calls between Donna around the time of the murder as well. The fact she also fled. I mean, there's so many indicators that Donna was fully wrapped around the axle on this murder plot. And let's see. Although the court eliminated the requirement that there be proof that defendant's presence at the scene of the crime, it did not eliminate the text requirement that be proof of what the defendant did or said in connection with the unfolding of the crime that helped this. She was an integral planner. She was a main operational planner of this, as I've said, for over 3 years now. So anyway, this is just all just one-sided stuff. It's not really taking any credible analysis of the evidence. State serious count 2. This is the conspiracy to commit first degree murder. It's really the same kind of information to support this. The intent of Donna was that first degree murder be committed. To carry it out, she agreed, conspired, combined, or confederated with Charlie or Catherine or other people to cause first degree murder to be committed, either by them, one of them, or by some other person. So circumstantial evidence showed that as well. The same kind of stuff I just talked about. And think about the conversation TV for five that she had with Charlie when the bump happened. So that also shows she knew about the code before the murder happened because she was the one that involved with getting the TV. So the TV directly ties to her and the code. If you're tied to the code, you're tied to the murder. Very clear. And they talk about it wasn't conscious of guilt, it's rather evidence of a real fear that a witch hunt would continue. Anyway, this is just such spin and leaving out all the key details. And then solicitation to commit first degree murder. That's the third count indictment. That one is Donna solicited Charlie or Katie or somebody else. And during that, Donna command encouraged. She'd encourage, yeah, she encouraged Charlie, right, to follow through with that. I know you come through for us. All that is circumstantial evidence, and circumstantial evidence is very solid here in this case. The trial court denied and erred in denying the defense motion for a new trial because the verdict was contrary to law or weight of the evidence. They're saying it was fair of the court. The state's case mostly consisted of a motive in search of evidence to match. Here's another AI. Well, I guess one doesn't have to be AI, but look at how sloppy this is, guys. The problem with the trial court's ruling here is that there was no evidence presented by the state to support its charges against appellant. Yeah, okay. Where's that big gap right here? And they go back to talking about principal of first degree murder, didn't present any evidence. They just gloss over the details. There's so many intricate details that really blueprint this. Let me move ahead here. Again, they just talk about generalities. No evidence, no direct evidence. Okay, no direct evidence. Okay, what about circumstantial evidence? Overwhelming circumstantial evidence. The primary evidence was motive. Motive was a huge evidence factor, but you got a lot more than just motive. No, she didn't mention anything in passing. She was an integral planner. Anyway, this is just it's very this is something like a first year law student would do better than this and come up with the details, analyze the. I'm surprised if they're using AI, they didn't come up with better analysis. AI can really have some phenomenal analysis. It can be phenomenally wrong too and leave out a lot of stuff. I mean, you could create an AI brief and basically say, write this brief, but omit the details that make Donna Adelson look guilty through circumstantial evidence, and they'll leave out all that. So that's the way you can manipulate stuff. Okay, then they talk about constitutional claims. Due process right to a fair trial was denied because she wasn't permitted to show any emotion in the presence of the jury. Court admonished appellant on numerous occasions she's not permitted to show any emotions. Yeah, because she's trying to disrupt the proceedings. That's typical in America. If you have a disruptive person in the courtroom, they're not going to let the judge just sit there and go, well, I can't do anything in my courtroom to maintain order and dignity. I can just have people acting out, throwing little fits and temper tantrums, having these outbursts. So anyway, this one's they're grasping at straws. So they're trying to say, well, look, the judge was telling her not to show emotion, but yet during the lack of her not having emotion, made it appear she had no remorse. This lack of remorse was taken into consideration in the court at sentencing. Due to her lack of emotion during the trial. No, she did have emotion in the trial. The judge was telling her to keep a lid on it, and this made the appellant appear that she showed no remorse. Why would she have what kind of remorse? You talking about remorse for being involved in the murder? That's not a good choice of wordage here. So the court's limiting her emotion to trial was used against her at sentencing. When imposing a sentence, the trial court took into consideration the utter lack of remorse that you are displaying. Yeah, that's just they're throwing up anything they can come up with. Whoever wrote this, whether it's AI or in part by these attorneys, they know this is really a weak appeal. And then they're talking about how they violated her right to have a meaningful opportunity to knowingly, intelligently, and voluntarily make an election, whether she wants to testify or not. I mean, we knew that was going to happen. So she just stalled. She stalled. She was terrified to testify. So she panicked and didn't want to have to make a decision. So the judge sort of did say, we're going to have a decision. You're not going to be able to stall this out. We got a jury here waiting. Think about it. Donna, who was as chomping at the bit to be able to defend herself and explain how everything's wrong, what they're accusing her of, she didn't want to say it. She didn't want to say it to the jury. She knew she'd be shredded on cross examination. Yeah. What if, so imagine this, folks. Imagine if a defendant just constantly says, I'm not prepared for trial to be able to state whether I am willing to testify or not, Your Honor. I haven't made up my mind. You think a judge is going to let him string this along indefinitely? No. You got to have some order in the courtroom, and that's just something attorneys with their clients are prepared to testify. And then if they don't want to testify, usually it's the attorney advising them. I don't think you need to testify. It's ultimately your call, but I don't think you need to testify, and here's why. So this doesn't need to be a drawn out thing. They had a long delay in this trial because of Donna wanting time to speak with Fulford and Zellman. Okay, because appellant was pressured by the trial court to make a decision when she clearly advised him she needed more time to speak with attorneys, it became clear she was vacillating on what the decision whether to testify or not. When the trial court asked appellant if she understood her rights, appellant is Donna. If she understood her rights regarding her decision to testify, she answered in the affirmative. In order to determine whether constitute a valid waiver, the court must look at the totality of circumstances. Factors to be considered are age, experience with the legal system, pressure or coercion, and clear and unambiguous language. Wow, during the trial, appellant was 75 years old and never even received a traffic citation. As the colloquies reveal, appellant was clearly pressured not only to make a quick decision, but her response to the trial judge's question were not clear and unambiguous. Okay, I mean, that's a lot of spin here, saying pressure to make a quick decision. That's not true. Judge was very patient. She was just stalling. She kept stalling, so the judge wouldn't let her get away with that. And then they finally go to the cumulative errors. Talk about the media coverage. Anatomy of a hit in Tallahassee Democrat, ABC News, saying records have been made public spoken how the family of Demerkel's ex-wife was connected to his murder as a hit for hire. different ones about Donna Adelson or just the Adelson name. Matriarch of family caught attempting to flee. The reporting in this case was inflammatory, emotional, and inaccurate, which distinguished them from reporting of straight facts in cases where change of venue was not required. Even when these stories report on newly released facts, they took information out of context, used inflammatory language so as to strongly suggest appellant's guilt. There was also a tremendous amount of prejudicial inflammatory editorializing in this case. All right, well, you know what? All those people were questioned on the jury and they answered in a way that really, if they did hear about it, they had not formed any opinion about it. It was very sketchy memory. This case is very old. It was around 10 years old at that time. Okay, so then they're going to do this cherry picking. Oh, yeah, out of 150 potential jurors, they had 3 jurors that came to question individually. Anyway, look at this. I don't even know what they're arguing here. It's just the change of venue thing is. Are they going to talk about that they botched it by not submitting a request for change of venue in writing? Really on the mystery evidence review for abuse of discretion. Look at they don't even talk about how the fact that they failed to do their rudimentary requirements, the base requirements under Florida law are that you have to file it in writing and you need to do so to preserve it. So they did not preserve it. So they're not talking about ineffective assistance here. That'll be done after this appeal is denied. And they're talking about this adoptive admission, some email that the state admitted that had to do with some conversation in a email. An email from Donna to Wendy. Donna told her what Charlie Adelson said in court was the truth. Because there's no evidence to show Donna went to or watched Charlie's trial, the testimony about this email should not be entered into evidence as adoptive admission. All right, this is nothing here. It's absolutely nothing. So there we have it. They're just you could basically have AI put this together in like 10 minutes. It's like a 10-minute brief. But it's so wrong and misleading in so many ways. So, all right. If you guys have any questions, so we don't know for sure whether it's the actual AI created brief, but some of the main indicators here. Let's look at these here. Stand by. Here's some of the indicators of internal inconsistencies. So the citations, when the brief cites Staten, 519 Southern, second, that's Southern Reporters, second at 638, and it looks like it's got a little quotation, and then 68 in one place, and Staten 592. See, it's 519, and then it goes to 592, and then it again has that quotation mark a few sentences later, 2 different reporter volumes for the same case and same pinpoint discussion. This is either a drafting typo or if AI sits, it kind of citation drift that large language models are known to introduce when regenerating a citation from memory rather than copying it consistently. Then you also have grammatical and typographical errors that a proofreading pass should catch. As it was clear throughout the trial, the was no direct evidence. 67 missing there, and denying appellant's motion for a new trial. 58 missing apostrophe. Underlying offense instead of underlying offense. None of these individuals unusual for a human drafted brief, but the density of small errors across a filed appellate brief is somewhat higher than usual for that polished final filing. And usually high, let's see, and usually casual, non-legal turn of the phrase for an appellate brief. Look at what this says here. Appellant asks this court to consider the evidence against her without the state's spin placed on it. While the appellant suggests crazy and highly offensive methods to Wendy, the word crazy and phrase state spin read as an informal register, inconsistent with otherwise formal tone of the rest of the brief. This kind of tonal inconsistency, formal boilerplate suddenly interrupted by colloquial language, is also known as an artifact of AI assisted drafting, where the human lightly edits AI output and some conversational phrasing slips through, though it is equally consistent with the advocate's own unedited voice. And they also have some stray, apparent orphaned footnotes and citation markers. The conclusion section at the end floats 222 immediately after the final sentence, followed directly by a section heading. This looks like a leftover artifact, possibly an unclear footnote reference or an editing or formatting error rather than intentional content. So the bottom line, according to this AI review of this document, is that the most telling signals here are repeated large blocks of nearly identical argument across two separate sections. So citation, detail drift. Both patterns show up in AI-assisted drafting when content is generated section by section without a final consistency check. But both also happen in conventionally human-drafted briefs assembled from multiple drafts under time pressure. Now, they did have time pressure. So none of this is proof of AI authorship alone, but they treat it as worth a closer look there rather than a conclusion. So, all right. This is my voice here. All right. So, do you guys have any questions? Skier, you're asking, are the attorneys still billing Donna? You'd be embarrassed to put your name on the document. I think it's probably a flat fee rather than a hourly rate. Yeah, April. Yeah, Wendy's phone call rate drops Wendy in it for going to the murder site. It's all the proof Wendy was involved. Yeah. He's talking about 1 in a million odds that she happened to go there to the crime scene a little over an hour after the murder happened. Okay, Ryan, you're saying, hey, Carl, which do you think is the dumbest? The sloppy, catchable murder plot, the stupidest defense strategies, or these nonsensical appeal attempts? Um, what I would say is the first, this sloppy, catchable murder plot. And the reason being is if you do something this stupid and you leave this much of a trail behind and all the circumstantial evidence, then you have to resort to really stupid defense strategies and nonsensical appeal attempts. So it's an automatic outflow of that. So when you do something that has all these indicators of guilt and there's no way you can point the finger at somebody else because you have all this data, all these details that all points the finger at these Florida Adelsons, that's what really is the thing that's just so baffling. It's such a crazy, ridiculous plot. LM Or you're saying, what does Georgia do in response to this? Nothing, because this is at the appellate level. There's appeal lawyers, appellate attorneys for the state of Florida that would handle this. They may talk to her about it, want to know what she thinks about certain details, or they may talk to maybe other attorneys in the office. But no, she's not going to take part in any response brief to this. Kathy, why did Charlie and Donna think they would have been found innocent in Miami? Well, I mean, that's just automatically something they're going to try to do is like say that we, by changing the forum from Tallahassee, where the murder happened, there's all that publicity there. And because of all that publicity, we couldn't get a fair trial. That's a normal thing somebody's going to ask the court to overturn a conviction for. But here, it wasn't that well known in Tallahassee. Still isn't to this day, where you can't seat a jury. And like one of the things that can happen is a judge may say, okay, I'll transfer it. I'm going to transfer it to Pensacola. Pensacola is out at the western panhandle of Florida, and that's like the most conservative part of the state. So they want to be down in Miami because then they're closer to home, and there is a better chance of a defense outcome in a bigger city. Catherine is asking, did Rashomon not get Charlie to sign the waiver because he would need to pin it on Charlie for Donna's defense? That has to go with his specific intent. I don't know if there was anything intentional for that, or if it's just careless, sloppy, lack of awareness of conflicts and how this could blow up everything, and him trying to represent Donna, and it's going to turn out to be something that blows up for Charlie too. So really, he can't represent either one of them. And so I'm telling you, I really believe Charlie's conviction will get overturned because of this conflict issue. Look at this. Adelson intelligence is AI. Well, this murder was not intelligent at all. It was one of the most wacko type murders you could plot. Yeah, that's true. AI would have not have been needed for deadline extensions, but maybe they're just so far behind they finally asked somebody to help them out that knows AI. Is it going to more or less instantly fail? In my opinion, Carl, I don't think there's any legitimacy to any of these points they're raising. Jim, you're saying the attorneys are required to zealously advocate for their client. They slanted the facts. Should not be a surprise. I'm sure the prosecutor's the same in their brief. It's one thing to like argue the facts most likely in your favor, but to say there's no evidence is such a far stretch, extreme stretch. Yeah, Lee's got it right. It's just such an amateur brief. Yeah, imagine if Donna would have testified, how she'd have been hollering and yelling at Georgia if when Georgia would have crossed her. Do you think that would have turned out better for her? Yeah, that's true. Bryn, you're saying she declined to testify, saying not at this time, as though there would be another time. Yeah, that was another effort to manipulate. I wish the judge would have said, no, it's this time. Now's the time. There's not another time. But despite the lack of further inquiry by the judge, I don't think this Court of Appeals is going to believe that she was rushed to make a decision. Fletcher, can Fulford file an amended brief to replace this? I don't think so. They already got an extension. Yeah, prime time. You're saying the judge gave her multiple opportunities to think about whether she wanted to or not testify, plus it's something she had a year or two to figure out. It's like she was never prepared to testify, so I don't know if that'll be part of the appeal brief or the other post-trial conviction where they try to attack the conviction based on ineffective assistance because Rashma maybe didn't prepare her. Excuse me, Fulford and Zellman didn't prepare her adequately. Sorry, I'm mixing those attorneys together. We really wanted her to testify, didn't we? Yeah. She was given so much extra time to make up her mind and whether to testify. I think she wanted to, but she was ultimately terrified of being crossed down by George. Yeah. I've never seen anybody so scared to testify and make that decision. I've never seen it before. Yep, judge was great in this case. He just missed that part about the conflict with Rashbaum. Christina, yeah, she was seething at her sentencing. Zero. Jenny B, I want to be covering the Brightigan case, so don't count me out yet. I just been too busy to cover it right now. But I want to play some catch up here. I just want to cover this one tonight, though, on Donna. Are many of you guys following the Brightigan case? There's multiple trials back to back, at least two. I guess I think there's a third one. Yeah, I wonder if the cases cited are real or AI hallucinations. Yes, I think that their efforts to harmonize this case, the facts of Donna's murder involvement with the Denise Williams case, I think is not a good comparison. That was sketchy, way sketchier compared to this one. There's such a large amount of evidence circumstantially that paints a really clear picture of Donna's involvement. She wanted this to happen. Fletcher, yeah, you want her to receive proper medical care for her arm because I want to live to be 120 in prison. Yeah, did you hear about that? They needed like an extension because she had some kind of tennis ball sized growth under her arm. Florida court reporter, did you hear about the jailhouse witness, Donna's buddy, who has now turned state's evidence, has been arrested again? Is that Drina? Q, did anybody see SDS episode with Tim Jansen tonight? He speculated they could be waiting until all the appeals are exhausted to go after Wendy in case they need her for a future retrial. Well, that's good. He sort of is talking not as pro Wendy. I think they're waiting mainly for Charlie's case, or they need her for Charlie. I don't think they need her to testify to get convictions on these characters, but she's not going to get away with it, folks. She's not going to. Mark my words. She's not going to get away with this. It's a whole reason. The whole reason that my brother was able to twist my arm into doing an interview that then got me that he then posted on YouTube, and then STS found out about it, and that's how I got on their channel to talk about all these indicators. Florida court reporter, why write Mr. Markell and then Dan Markell? Well, they also had Danny Markell. AI companies are exaggerating their abilities. There is some really phenomenal stuff that they can write. I mean, you talk about eloquent writing. I've seen some really eloquent writing, all 100% done by AI. Lee, Tennessee. It sounds more like a gossip blog than a legal brief. Robin Hood, I believe the state's response is going to be a beautiful thing to behold. Oh, speaking of John, I see John sign in here at 10:31. Thanks for keeping the chat clean, folks, and professional. Um, I really don't have any mods having to do a lot of cleanup ever. So appreciate that. We're here to have a discussion on the law. I'm trying to talk about it as if I was talking to lawyers about burden of proof, tactics. Yeah, thanks, Nancy. I think you're the one that told us about this brand of treats. LJ's skin is doing better, better and better, continually doing better. So thank you. It's hard to believe that just something you give as a food additive, little special treat can help stop a cat scratching a wound, bloody raw every day. Yeah, Stevens, you're saying Katie got the info from Wendy as a bombshell. Yeah, I mean, think about it, because Fulford in court made references to Wendy. You know, Wendy, look at Wendy, not Donna, or however those direct words were said. Alex Perkins. Well, at this point, it seems Donna's best comeback is horrible AI attorneys. So she's basically putting everybody else is involved in this except her. It wasn't her, it was Charlie and Katie. But then she's sort of bobbing and weaving, also talking about, well, it wasn't meant to kill him, it just meant to hurt him. And so it's just, how can you even follow this nonsense? JBZ, you can't understand why Charlie's not throwing Wendy over the bus, or normally it's called under the bus, but I think that'll come down the road when he has a chance to get his conviction tossed and he's starting from fresh, brand new first efforts. It's like this whole trial never happened. And then if he gets an attorney that's not in it for a lot of money and is going to tell him the truth, like, look, you're not going to win a trial the second time. You need to come clean and give them the evidence they need. Do you have any corroborating evidence of others' involvement that have not been indicted yet? That's what he needs to give them. And that's when I think the dam's going to break. All the circling wagons around. One of the last main co-conspirators, the one who's unindicted, I think is going to come crashing down. Yeah, think of all the millions of dollars they've blown on these defense lawyers. I cannot believe the lack of quality advocacy for so many of these co-conspirators. Yeah, you can't make this stuff up. Let's see. Yeah, thanks for correcting me. Funeral home. I think I said nursing home a couple times. Sorry about that. Standard Poodle, didn't Charlie have the idea to murder Dan? Well, we don't know who exactly came up with the idea that verbalized it, but who kept feeding the fire of hatred down in South Florida? Yeah, it's just I think this case can really show you how there's not perfection in a lot of trials that take place in America, in both civil and criminal cases. Here we have so many issues swirling around, things that are really just head scratchers, shake your head kind of stuff that attorneys do from the prosecution and the defense, mostly defense. Think about these lawyers representing the co-conspirators that all went down, except for the one that had Luis Rivera plead guilty. He was court appointed. Luis Rivera is going to come out the best of all this. Catherine, you're saying Donna's lawyers are not appellate specialists. Do I think it's a sign they're running out of money? It could be. I suspicious. I don't know. Maybe it's just that Donna doesn't know who to ask, and Harvey is tired of trying to find lawyers. So I don't know. Maybe they offered him a discount. He wants to save some of that money for himself so he can flee the country, maybe. Yeah, Luis, it's more like 2033. It's not as quick. Yeah, Robin Hood. That's what I've been saying for a long time. Charlie, when he realizes either his appeals are exhausted or he gets a new trial, that's the time I think a conflict free counsel is going to say, time to give it up. You're going to go down a second time. Why are you going to waste your efforts? Do you really want to be able to escape prison someday? And here's the thing is Charlie has not filed an appeal with the Supreme Court of Florida. So is he going to file a motion to Judge Everett challenging the conflicts issue that Rashbaum created for him? So it could happen pretty quick. You know, we talk about these appeals lasting for years and all that, but if they don't appeal it to the Supreme Court and they do a motion to the judge, I think Judge Everett might disagree. He's already said Rashbaum was ethically in violation of Florida law by representing Donna. So I think he's going to extend that same thing to Charlie. And by Charlie, that's per se conflict of interest. And they'd have to go into some more of the facts of the case and how he was really not able to help both of them equally. One of them he had a favor over the other. And given the fact that Donna was his client for years before this, it appears that Donna was the one he was really trying to protect. And he even called Donna his mother, a mother-like figure on STS. So I think I'm going to go through here, and I think it's worth seeing one more time here. The Donna Adelson verdict announcement. right. This was it's just sometimes it's just like hard to imagine that being there in that courtroom listening to this from the sort of back angle. Leslie was with me and Johnny was there, and us three watching this live is pretty I find it really hard to believe. Check this out.
Welcome back to Court TV. Let's get you right back.
Proper order. At this time, I will publish the verdict. We, the jury, find as follows as to count one of the indictment, first-degree murder. The defendant is guilty of first-degree murder. Mrs. Adelson, control yourself.
That was delayed reaction on Court TV. Sorry. Let me try. Here's another one.
If
Does she look confident that she's about to go home? She's dreading this. These are the worst words she's ever.
having reviewed the verdict form, it is in its proper order. At this time, I will publish the verdict. We, the jury, find as follows as to count one of the indictment, first-degree murder. The defendant is guilty of first-degree murder. Mrs. Adelson, control yourself. Count two. We, the jury, find as follows as to count two of the indictment. Conspiracy to commit first.
Now think about it. How many times do you see somebody getting convicted at a trial and you see an outburst like this and anger like this, right? Charlie just put his head down. He knew all these efforts to bamboozle and trick the jury and all that money spent were in vain. Donna, her anger, she cannot control her anger. This is some of the anger and her inability to control herself that now her defense lawyers are blaming the judge for not letting the jury see emotion and remorse. Does this look like somebody that's remorseful?
Degree murder. The defendant is guilty of conspiracy to commit first-degree murder. Count three. We, the jury, find as follows as to count three of the indictment. Solicitation to commit first-degree murder. The defendant is guilty of solicitation to commit first-degree murder. And it is signed and dated by the foreperson.
Nobody at her defense counsel is surprised. They all expected it.
One moment. Members of the jury.
Donna expected it too. I really believe that. I think she's just doing this. What? You got to be kidding me. It's all theatrics for her friends and the grandsons.
The bailiff will escort you to the jury room.
You know what? There's no tears there. It's all fake crying. So we've seen this before. It's like she's sobbing, but who sobs and doesn't have...
Mrs. Adelson, while this was not the outcome I'm sure that you desired, there will not be any further outbursts in front of the jury. If you cannot control yourself, I am going to have to determine if you'll be removed from the remainder of this process.
Man.
Do you understand what I'm saying to you? Do you need a moment to collect yourself? Before the jurors are brought back in, we will take a brief 2-minute break. Please give her tissues if she needs them.
He doesn't, because she's not crying. It was an expected outcome. So anyway, it's just one of these deals. If she would just agree to cut a deal, Catherine, you're asking if Josh and Jackie would have known before the verdict was read that it was a guilty conviction. Are the lawyers normally given a heads up beforehand? No, there is no indication whatsoever. The heads up you can see, though, is every single time I can tell you, is every single jury that I've done a lot of jury trials over the years. I can tell you, every time a jury comes back and they look at the defendant, they're giving them freedom. They like looking at the defendant. They like looking at the fact that they're going to be really excited when they hear the verdict announced. If they all file back in the courtroom and none of them are looking at the defendant, automatically, you know your client's going down. Okay? Automatically. Thankfully, that's rarely happened for my clients when I've been on the defense, but Nano, you're saying every time she cried, quote unquote, she checked to see if juries were looking at her. Kim, you're saying I take the words out of your head. Donna's like a toddler tantrum. Charlie even had more control than that. So yeah, this appeal brief that I've been covering tonight, if you're joining late, it's just sort of all over the place. It looks like could be AI written. There's a lot of typos and errors on it. They even had extra time to file it. They said there's some impediments to being able to file it on a timely basis, but yeah, I think it's somewhat satisfying, but justice is not done, as the Markells have said. Justice is not done till every last person responsible for their son's vicious, cruel death is held accountable. Yep. Carmi girl is so jealous that Carl got to witness that in person. I know talking to Leslie the other day, it's like, can you believe it that we actually saw this live? I feel like I wasn't even there, really. And Leslie felt the same way. Enough for truth and justice. It's not the outcome she desired, but it's certainly the outcome Donna deserved. That is true. Yeah, it was all about manipulative showing who's boss. So yeah, Judge Everett, hope you're doing good. I know he watches some true crime. Jim, you believe that there's no way Donna could have believed she would be acquitted? Oh, Carmen girl, you're saying you text your whole family who could care less about the Adelsons and celebration. Paralegal Mandy, this is a good reminder of the special day that justice visited again for the murder of Dan Markel. And it's not done yet, folks. Mark my words. Tenacity is Harvey paying for Charlie's appellate attorney. I would say maybe, but maybe some of those rental units are being sold, and that's how they're funding all these attorneys. Oh, really? Is that the way for you guys? Carmi Girl Senate has become I remember where I was moment for you, LOL. Are you serious about that? Is it sort of like 9/11 where you never forget where you're at when you heard about it? Yeah, Ollie, you got a good point here. Offerman was a good choice by Charlie. He's the only Adelson lawyer worth their salt. He's like one of the best of the state, if not the best appellate attorney, right there in Tallahassee too. He's not going to. I mean, his win rate is really slim, but if you have a shot, I'd say Offerman's your chance. And if he explains the conflict dilemma that Charlie had in hiring Rashbaum, and Rashbaum hid the ball from him on a number of different areas, including the not having a written waiver, not advising him of the fact that he doesn't really want to get Donna involved in helping him testify because that's a bad showing for Donna. Who's he representing more zealously, Donna or Charlie? You can't have it a 50-50 equal or 100% across the board. One of them you're going to be more loyal to than the other, and that's a per se conflict, especially on something like a murder case. And as I said the other day, there was a advanced criminal law continuing legal education course here in Texas that I took, and they talked about somebody that made a comment in the ethics portion. They said, yeah, just like nobody's going to represent two different parties in a murder conspiracy case. And I'm like, they do in Florida for a little while anyway. Rick Grimm, you're saying Charlie needs to read Wendy's book. I don't think he ever did. He would see that he was being played like a fiddle. That's a good point. Yeah, it's Ufferman with a U, not Offerman. Linda Boyu, I think they're waiting for Wendy's kids to be older. When she goes to trial, then jail, they'll be teenagers around it. No, I don't. That's never a prosecutor's mindset. Yeah, the two you're asking if Donna has a chance of ineffective assistance of her lawyers. I do not think so. I just don't see anything there that's an area where they really dropped the ball, where that's going to be a basis to overturn it, where an outcome would have been different if she had had better counsel. That's the thing. You got all this circumstantial evidence. Great, phenomenal lawyers cannot take on circumstantial evidence. Direct evidence a lot of times can be attacked easier than circumstantial evidence. So let's see. Well, I've been on almost an hour and a half now, so I'm going to go ahead and sign off, but I do want to cover some more this week if I get a chance on the Brightigan case. Otherwise, do a wrap up this weekend on different highlights. But what else is going on there in Massachusetts? What I'm hearing about the prosecution is unreal. And it's going to come back to bite the prosecutor. So we'll talk more about that as well. So with that, you guys take care. I'm signing off. Have a great night. And hope to be on before Friday, but probably not until Friday. So otherwise, stay safe. Thanks for supporting justice. Take care. Good night.